Um, so greetings, everyone, and thanks for joining this webinar today. I'll go ahead and start with an acknowledgement of country, which is appropriate since this is regarding the rights of Indigenous peoples within the region. For those of you who are not familiar with the idea of acknowledging country, this is a practice that has started in Australia, and it's been a pleasure to see that it started to expand into other jurisdictions, increasingly in places such as North America and elsewhere. Basically, the way it goes is that we're meeting through the Australian National University, and the campus is situated in the lands of the Ngunnawal and Ngambri peoples. So we acknowledge the elders past, present, and those emerging, and we pay our respects and recognize the fact that there are continuing issues of sovereignty and that which continue to call for resolution. We thank everyone for joining today. This session is the inaugural session of a planned webinar series. This will continue on for the next several months. We are progressing around the Asia-Pacific region, and each webinar will be devoted to a separate set of countries. This is not meant to be a comprehensive survey of all the countries in Asia. It is meant to highlight certain countries that are experiencing Indigenous rights struggles. Today is focused primarily on the places we call Oceania. So this will cover Australia, New Zealand, and then later on West Papua. It is our pleasure to host speakers who are speaking directly from their own experiences. So Dr. Virginia Marshall, Dr. Carwyn Jones, and then Wenceslas Fetibun. The moderator is Sarah Thompson. The way this will work is that we will have each speaker make a presentation of their country in sequence. Sarah will be moderating. We will ask that the audience, if you have any questions, please use the Q&A feature at the bottom of the screen in Zoom. So not the chat feature, but the Q&A feature. So please type your questions into the Q&A area. That is accessible by the moderator as well as by the speakers, and then they can go ahead and respond to your questions either by typing answers or speaking directly during the Zoom session. This webinar series and today is being run by the Australian National University College of Law. However, it is being done through a collaboration with the American Society of International Law, specifically the Asia-Pacific Interest Group and the Rights of Indigenous Peoples Interest Group, of which I am a co-chair. It is also being done in a collaboration with Law Asia, which is the Association of Law Associations in the Asia-Pacific, and I am also a co-chair of the Indigenous Peoples Committee for that organization. We hope to maintain this collaboration going forward. This particular subject matter of Indigenous rights and Indigenous struggles with the Asia-Pacific is one that we feel deserves attention. Quite often, the Indigenous rights discourse is dominated by North and Latin America, and we're hoping to try and increase awareness for global audiences of the Indigenous movements within the Asia-Pacific. So with that said, I'm now going to turn everything over to Sarah. And Sarah, the floor is yours. So thank you.
Thank you, Jonathan, and thank you to everyone who's joining us today. It's a pleasure to be able to moderate the first of this exciting series. I'm really looking forward to the discussion today. As Jonathan mentioned, we'll have the first half of the webinar will be some presentations. We've got some really exciting speakers. We're joined from Aotearoa with Dr. Carwyn Jones. From Dharawal country, freshwater country, we have Dr. Virginia Marshall. And joining us hopefully shortly, we have Wenceslas Fetibun, who is, I think, in the air arriving in Aotearoa soon as well. So really looking forward to the discussion. We'll first of all start off with a short presentation by Dr. Carwyn Jones. He's a Maori legal scholar from the Ngāti Kahungunu tribe and is a lead academic in the Maori Law and Philosophy program at Te Wan Anga Orawo Koroa. Sorry if I've mispronounced that, Carwyn. It's a Maori institution of higher learning based on Otaki in the north of Wellington. He's also an honorary adjunct professor at the School of Maori Studies in Victoria, um, and a former president of the Maori Law Society. Cowan's research focuses on the Treaty of Waitangi, Maori law, legal issues affecting Indigenous peoples, and has published some very impressive works, including a new treaty, new tradition, reconciling New Zealand and Maori law, as well as treaty law, the principles of Treaty of Waitangi law and in practice. Looking forward to hearing from you today, Cowan, especially in light of the protests that have been happening with the Treaty of Waitangi.
Tēnā koutou, ngā mihi ki a koutou, ka tautoko ngā mihi kua mihia ki ngā iwi taketake. So just wanted to acknowledge the greetings that have already been made and the acknowledgement of country, and also greet everyone who's online today. So I've just got one slide that I'll bring up to share with you. And the image on this slide I thought might be a good place to start my presentation. So this is an image of Hana Rafiti Maipi Clark, who is a member of parliament. She's the youngest member of parliament at the moment, and is one of the youngest members of parliament that we've had in Aotearoa. She's a member of Te Pāti Māori, or the Māori Party, and she's shown here beginning a haka. Some of you might be familiar with the haka from the New Zealand rugby team. The kind of it seems a bit strange to describe it as a dance, but it's often described as a kind of war dance. She's leading off a haka here in our parliament as she tears up the principles of the Treaty of Waitangi Bill, which is currently before Parliament, and which is the cause, or one of the causes really, of significant protests, where we had estimated between 80,000 and 100,000 people on the grounds of Parliament just around a month ago. But to understand what the principles of the Treaty of Waitangi Bill is all about, I sort of need to take you back a little bit to talk about, first of all, what the Treaty of Waitangi is, and then sort of work through a little bit about the ways in which New Zealand has engaged with Māori rights. So the Treaty of Waitangi was signed in 1840 between over 500 Māori chiefs and a representative of the British Crown. And it essentially did a number of things. It's quite a short document, but the kind of main things that it did was that it agreed, the chiefs agreed that the British Crown would be able to establish a form of government here in New Zealand. Now, there's some debate as to exactly what the scope of that governmental authority ought to be. There's the recent scholarship and research tends to suggest that the rights that Māori were providing of governmental authority were not intended to be over Māori themselves, but was allowing the British Crown to exercise governmental authority over its own subjects who were here, over the settler population that was here in New Zealand. Now, part of the reason why people suggest that it was only intended to be governmental authority over the settler population is because the other thing that the Treaty of Waitangi does is it guarantees ongoing Māori authority. And that's described in the Māori text of the treaty as tino rangatiratanga, and the kind of root word there is rangatira. It's the word for chief or leader, rangatiratanga is those things to do with the chief or chieftainship or leadership, and the tino at the start of that is an intensifier. So it's all those very special qualities of chieftainship or absolute chieftainship. We often use it today to talk about Maori self-determination. Now, importantly, that's a that's not just a protection of particular lands or forests or fisheries or tangible property, and it's not just a protection or a guarantee that particular customary practices would be able to continue, but it's a guarantee of ongoing political authority. And so the way in which most people, I think, come to describe or talk about the Treaty of Waitangi today is that it set up a relationship between these two spheres of authority. It created a space for the British Crown to exercise that governmental authority, and it guaranteed that that Maori authority would continue and be maintained. Now, the government largely went on almost immediately after 1840 to act as though it had secured full and exclusive sovereignty over the whole country, and largely ignored the guarantees it had made in the Treaty of Waitangi up until really the second half of the 20th century. And one significant change there, and I've noted on the slides, is the establishment of a body called the Waitangi Tribunal. And this is a commission of inquiry, so it's not quite a court, but it operates in many ways like a court, but it hears claims made by Māori that the principles of the Treaty of Waitangi have been breached. And it reports on those, it makes findings about where those breaches might have occurred, and it makes recommendations to government about how to address those. Importantly, the tribunal largely makes non-binding recommendations. It only has very limited authority to make any binding orders, and hasn't ever fully used those powers. So it's making recommendations to government that government can choose to either accept or ignore. Again, because of the way in which the treaty itself is structured, the tribunal isn't just dealing with land claims, although that has been a large part of the tribunal's work over the nearly 50 years now of its existence. But it also deals with the way in which the principles of the treaty apply in the context of contemporary policy kinds of issues. So, for example, one quite significant claim and report of the Waitangi Tribunal from the 1980s was in relation to the Māori language, and it was from recommendations from the tribunal that led to Māori being recognised as an official language of New Zealand, led to an establishment of the Māori Language Commission, which supports transmission, promotion of te reo Māori, Māori language, and other measures like that. So it's always dealt with these kinds of policy issues, and it continues to play that role even as some of the historical claims are winding up. Now, the tribunal established in 1975, that was the first instance in which the government had used this idea of the principles of the treaty in legislation. And it uses the principles partly as a mechanism to get away from some issues around discrepancies between the English text and the Māori language text of the treaty. But also importantly, it uses it to ensure that the treaty isn't kind of frozen in 1840, but that the big ideas that underpin the treaty will be able to be applied to changing circumstances over time and still relevant in the 20th century and 21st century. So now, but the Parliament didn't define a particular list of what those treaty principles are. It left that to the Waitangi Tribunal to do. It also then began to insert this phrase, principles of the treaty, into other pieces of legislation. So our Conservation Act, our Resource Management Act, our State-Owned Enterprise Act, there are a number of pieces of legislation which now require some consideration or adherence to the principles of the Treaty of Waitangi. And when those matters have come before the courts, again, it's the courts who have interpreted and applied the principles of the treaty in their particular context as the cases come before them. So there has never been a kind of a statutorily defined list of what treaty principles are. And in fact, the use of it in legislation of that concept is really more of a kind of interpretive cue to the tribunal and the courts to not to be bound by the kind of the rigid text of the treaty, but to think about the ideas that underpin it. Now, and this has led to, partly through the work of the tribunal, but partly through the kind of adoption of the principles of the treaty as a kind of key mechanism by which government gives effect to or recognises Māori rights. It's underpinned a lot of change, or incremental and hard-fought change, often in terms of government policy across a whole range of areas to provide for Māori voice and input in decision making. Now, this has all been this had sort of been on a march of slow incremental progress really until over the last 30 years, 30, 40 years, until the election of our current coalition government, who has undertaken a program of really rolling back a whole lot of gains in relation to Māori rights, or progress that's been made on Māori rights. And they've done that in a number of different areas. So, for example, the previous government had established an independent Māori health authority to try and address the some of the inequities that exist for Māori within the health system. This government has disestablished that. Previous government had made changes to local government representation to try and increase or provide options for particular Māori representation. This government has gone back on that. There have been changes in child welfare law which have taken away the requirement to engage with Māori about those issues. Been changes around Māori language and also customary title in relation to the foreshore and seabed. But perhaps one of the things that has symbolised this government's actions most has been the current principles of the Treaty of Waitangi Bill, which is stating that these principles, which have developed over 50 years in the tribunal and the courts, are going to be redefined as three principles which are set out in the bill, and that those would be put to a referendum. Now, we've got three parties in our coalition government at the moment, and two of those parties have said they will support the introduction of the bill, but they won't support it any further than that. So it does seem that it's unlikely to pass at this stage. But if it was to pass, it would be put to a referendum. And that then would have these three principles, which really the government's own officials in the Ministry of Justice have said don't reflect the treaty agreement itself in 1840 or the decades of interpretation and application by the courts and its use in policy over those decades as well. So it would be quite a radical reinterpretation. It would severely narrow and restrict and limit Māori abilities to make claims based on the principles of the treaty, because what you would be able to claim would be much more limited. And so part of the reason why it's provoked such a significant response, even though it may not ever come to pass, is because the stakes are so very high, because this is the key mechanism by which government chooses to recognise Māori rights, and they're kind of being completely hollowed out or removed by the principles that are being proposed in this bill. So that's a very quick brief rundown on the Treaty of Waitangi, Māori rights in New Zealand, mention of a few current issues, and I'm happy to come back and talk about some of those in more detail if people have questions about them. But for the moment, I'll leave that there. Kia ora.
Thank you so much, Carwyn. That was a very comprehensive overview of how the Treaty of Waitangi is being applied now and how it really disappointingly and shamefully is being reinterpreted, or that there's support to reinterpret it. I think particularly in the context of Aboriginal and Torres Strait Islander treaty making here, you show a lot of strength, and we have a lot to learn from Maori peoples and their treaty making when we're applying it in our context here. I guess that leads on to talking about Aboriginal self-determination and sovereignty and struggles here. We'll hear now from Dr. Virginia Marshall, who's a research fellow based also, like myself and Jonathan, at the Australian National University. She's with the Regulation of Global Governance, is also a practicing lawyer and leading legal scholar in the expertise of Aboriginal water rights, native title rights in sea country, Indigenous knowledges, and the intersection of traditional knowledge systems and Western intellectual property regimes, especially as it relates to Indigenous commercialisation of traditional medicines. Virginia, I've read so much of your work across the years. I'm really looking forward to hearing from you today, particularly, in light of the Voice last year and just where Indigenous struggles here are kind of going forward. Thank you.
Thank you, Managuru. Marangyaria, Yumanadi, Virginia Marshall. I'm very thankful to be on country and to share the opportunity not only to speak to all of you today, but also acknowledge our Indigenous elders and the incredible gift that they've given to us and to know who we are, and also to walk with dignity. And I think that's something that we all carry, and especially in relation to making incredible changes that need to be made in this very conflicting space right now. When I look at a lot of the issues that Carwyn spoke about, it first has to be acknowledged that the outcome of the referendum, the constitutional referendum in Australia, has really emboldened many people and many groups to feel that there needs to be change. We need to walk the road of assimilation instead of a significantly mature and decent population that would prefer to recognise First Peoples and recognise First Peoples not only through the tens of thousands of years, as we know in Australia at 65,000 plus, and artefacts in the Kimberley have been acknowledged as 80,000 years of very astute land and water management, the management of space, and management of culture, social order. There are so many areas that Indigenous people can hold their head high, and to know that we've contributed significantly to humanity. And also to the originators, I believe, of international law and the way that we really have interfaced with many of our other communities in a spirit of reciprocity and dignity and decency. So that's what we've inherited through our elders, through our knowledge and understanding of what we believe in and what we know, makes us keep going every day. So I think, it does concern me that those issues and it appears that for a referendum outcome, and non-Indigenous people, which were made up from many different cultures, and they had acknowledged that they wouldn't support the referendum. So we have to see that the outcome is also really, again, emboldened people who normally would go about their everyday without any specific targeting of Aboriginal and Torres Strait Islander people, and also undermining. And that's what we see post-referendum. When I appeared and presented at the past 3 COPs before Baku, I realised, how much Indigenous peoples have in common, which is colonisation, assimilation, and it's not of the past. And this is what we have to realise, is that the barriers that are created are really, in effect, very deep and ongoing in the work that I've been able to undertake over the years since my thesis on overturning Acta Nullius, which many of you would understand, was also to really highlight that it wasn't only terra nullius, it wasn't only Aboriginal and Torres Strait Islander people and Indigenous people being dispossessed of land, but land and water. And in Aboriginal and Torres Strait Islander understanding, you can't separate the water from the land. And that was my whole understanding of trying to share a deeper knowledge with the readers that, you know, when we actually are going through this current process, I'm an acting chair of a national Aboriginal and Torres Strait Islander water committee, and we've been working on the new national water agreement for Australia, and also working and negotiating with the jurisdictions, the states and territories and the Commonwealth, on how this particular new national water agreement should look like. And of course, it's not only dealing with water. All of our issues cross over to many areas of human rights, of the child, of women, of family, of identity. So it's not just water that we're talking about. We're also looking backwards to the first national water agreement that contained 3 very ineffective provisions, where no progress was really made for a very long time. And what we can see now, and this is one issue that Carwyn mentioned, you know, the non-binding nature of the tribunal, and the National Water Agreement is also going to be non-binding. And the most important thing to remember is that we have to see ourselves and express ourselves through water and the land together. So even though it's been separated in 2 parts, in water and land in Australia, that we have to always fight against that picture that we can neatly put all of these various areas of ourselves in silos. And I think that's also a great opportunity in this National Water Agreement, which should probably finalise in January next year. But we've done significant work to bring culture and the understanding of what culture is. It's not static. It's forever growing, and the deepest meaning of who we are is also really coined in those new provisions. So that's something that we've worked very hard to actually express. The other issue is the treaty. We've had a number of election changes. Different parties come in and out, of course, over the years, but a treaty by Queensland has been thrown out, and the report that the Northern Territory of Australia had conducted and finalised, that hasn't gone any further. It seems the only semblance of what we understand as the treaty process is still running in Victoria. However, again, there have been many people like Lydia Thorpe, who's a senator in the Australian Parliament, has mentioned very clearly that we're unceded peoples, and that is quite true. And as you know, many Indigenous people across the world have to fear for their life to identify as Indigenous. And we've seen that not only in Myanmar, but also in many areas of what we call civilized society in first world and developed countries. So we have to also understand that identity is something that people are also clearly not going to back down from. And another issue that we've had to in recent times from the opposition leader of in the federal parliamentary system has said that for example, that they would not stand in front of an Aboriginal and Torres Strait Islander flag, and also that those flags should be repealed under the legislation. So that's very concerning. And we've had also issues that relate to our human rights in regards to the age of criminal responsibility. In the Northern Territory, it's going to be 10. And they have said that it would only be for serious crimes, and we're yet to see that play out. But that's very concerning when we believe that 10-year-olds, and especially this will go to a rise in incarceration for Aboriginal and Torres Strait Islander children. These issues also have meaning and significant impact to community, and it affects everything, and that's to do with the treaty system, to water, to land rights. Land rights, we had this week the Kenby claim in the Northern Territory for the Larrakia people take 50 years for a decision to be made under land rights. And I keep on saying to myself, and I studied in criminal law, that if most people had to wait 50 years for a decision, that system would be a corrupt system. It would be a failure as a legal system. So we really have to understand that a lot of the issues that we're dealing with at the moment, with, again, very similar to Canada, many Indigenous women across Australia who are dying without proper investigations being done on many of them. And also men and women dying in incarceration, numbers are rising. Usually Australia decides that we'll just have more prisons to accommodate people in incarceration, particularly on remand, that Aboriginal and Torres Strait Islander people are held. So, you know, there are a lot of underlying issues that make the rights of Indigenous people a question mark, especially, again, as we're the first peoples of our countries. And respectively, I remember being asked to write a reimagined judgment from Akiba, which looks to whether there's commercial rights of trade that can be recognised by the High Court and prior to that from the Federal Court of Australia. And I remember very clearly that what some of the judgments deal with is not an understanding of our culture and our identity in those weighing up, you know, proportionality, etc., of who we are. And that particular judgment of Akiba for me missed the point of understanding the very many and important relationships we have with our extended family, which is also Papua New Guinea, and a very long trading and familial system that's been happening for a very, very long time. So when I wrote that area, the judge had obviously misunderstood what reciprocity is, and those deeper affinal relationships, those familial relationships with others in their family. And then the outcome would have been even much more important under the Native Title Act, because it would have also acknowledged as a precedent that other communities across Australia would have that benefit of having not only the land rights, but also the recognition of those very important familial rights. And it's something that we don't have. But just again, you know, there's so many issues that come up for the Universal Periodic Review, which I've been asked to contribute to this week. And I seem to see that we are really dealing with even more negative issues and issues of human rights and non-application to those instruments that we value. You know, the United Nations Declaration of the Rights of Indigenous People, even though we haven't legislated in Australia, it's important. It's still customary law in progress, and it must be acknowledged. It's not only ratification that will make a difference, but when we define acts and federal policy and states and territories policy, that it's really not meeting that test of human rights compatibility, that we really have to draw a line and say, well, this is not acceptable. And that's where we have a unified voice across the world. And some communities still, and in Australia it's the same way as looking at environmental issues, again, they play out in the areas of protest on issues of not meeting climate change and the expectation of, you know, have we got a world to actually to be able to live in. We're really well and truly running over 1.5 degrees. And we know the implications for traditional medicines, for bush foods, for all of the animals that we're related to across Australia and the various areas that we're obligated to look after. It just seems to be a runaway train when we've got to accept that we're going to 2 degrees. And, you know, and really important issues about how we are going to work together as global nations on understanding the importance of renewables and how we're going to transition in a whole range of different areas besides electrification and, you know, agriculture and land, etc. So there are so many issues that we have to deal with. And on top of that, many communities have sorry business. They have and live in poverty. In remote and rural areas of Australia, they have a card, which is a card for you know, $50 and $100 to actually put in their system at home to run air conditioning when you've got 43 degrees and whatnot. So we've got all of those experiences that really are part and parcel of our human rights breaches. So I just say that there are some wonderful things that we can do together, and I'd really encourage you to express those in responding to the Universal Periodic Review in relation to really bringing these to your attention. Manangu.
Thank you, Virginia. It's so wonderful to hear from you. And yeah, you're right. Our country is hurting, and we as Indigenous peoples have an obligation to protect it. And we can do that by drawing strength on ourselves and across the region. I really, yeah. Fataban has, Wednesday Fataban is joining us now. Thank you so much. Sorry, it might have been a bit of a hectic time off of the plane for you. You're in Aotearoa now, Fataban. So I'll just quickly introduce you before you start. Wednesday is a PhD candidate at the University of Canterbury. He focuses on media and Pacific studies. He's been working as a video maker and photographer, journalist and human rights defender with Indigenous communities in West Papua. Also in Kalimantan, the Flores Islands, and North Sulawesi. He uses video to advocate for the region and also at the United Nations for Human Rights. He's been working on investigative reports and making films since 2006, and also has some experience as the coordinator for monitoring, investigation and research for the Secretariat for Justice of Peace. You've got a bunch of other incredible accreditation, Wednesday, but I might leave it there and let you now speak on Indigenous struggles in West Papua, especially around the militarization and media restrictions that is happening there. Looking forward to hearing from you. Thank you.
Thank you so much. Kia ora, amakane, Pacific greetings for all of you. So Yeah, I just arrived from Riyadh, Saudi Arabia. Today we make one of the historical movement for indigenous peoples around the world because of UN member states. They adopted our resolution on indigenous peoples caucus at the UNCCD. So now we have access to bring more our voices to the international meetings like UNCCD. So in the introductions, I'm from West Papua, and my presentations is around introduction about West Papua, and try to link with the militarizations and also how the indigenous Papuans advocate on their right to self-determinations. So, West Papua is in 1st of December 1961, preparing for independent state, because at the time West Papua was under the Dutch colony. So at the times, people know that West Papua is they called with another names, Netherlands New Guinea, and but Indonesian governments, especially military, took over and becomes military conflict as well as a political conflict. So the transfers. So on 15th August 1962, so West Papua case they brought to the international flora and discussions. It is facilitated by U.S. government. So try to bring together Indonesian government and Dutch government to discuss about the future of West Papua. And at the time, the transfers administration from Dutch to Indonesia government under the New York agreements. And 1969, UN conduct the eco-free choice, or we call referendums. But for indigenous Papuans, it is act of no choice, because like my family's, my mother's auntie who attended the act of free choice, she explained it and shared to us that at the times under the gun, so indigenous Papuans doesn't have a feel free, doesn't have a free space to choose part of Indonesia or separate. So this is the one of the problem, and until today, so the indigenous Papuans fighting for their right to self-determinations. Some Papuans created the West Papua National Liberation Army. Is the arms group try to using the army approach to advocate or to support the indigenous Papuans right to self-determinations, and others like young Papuans, they create the National West Papua National Committee, or we call KMPB, to also advocate with the non-violence on the right to self-determinations in West Papua. As you know that West Papua is sometimes people call it New Guinea Islands, but for the Papuans we call it Tanah Papua, or land of the Papua, because for us, it is as the indigenous peoples, land is very important for us. Without land, we cannot we cannot have a future or good future. Or without land, we cannot claim that we are indigenous peoples. So the land very important for us. But today it is we lost our land because of two things. One is militarizations in West Papua, and second things, the economic developments conducted by the Indonesian government without West Papuans participate on that project, that regulation, I mean. For the militarizations, military, they are not only focused on security, but they also part of the economic development project. Like today in my village is more military presence. As 800 soldiers just recently mobilized to my village for working on food security project. So when military part of that project, that means indigenous Papuans become in danger. They don't feel free to express their opinions, to advocate, to protect their rights, especially land rights and territory, as well as protect cultural value, because under the gun. So we are living with the fear in West Papua, and for the economic development project, as you know that in West Papua since 2001, Indonesian government created new regulations for West Papua called special autonomy. So they give West Papua with the special autonomy law. But in the reality, it is not implemented. Sometimes Indonesian government arguing that or they have a special autonomy for West Papua, but in reality, not special autonomy, because in one hand we have a special autonomy, but on the other hand, when Indonesian government conducted or created economic development project in indigenous Papuans territory, it is without consult and consent with the indigenous Papuans. For example, myself, in 2020, I was arrested by the Indonesian military and police in my hometown, Merauke City. When together with indigenous Papuans, we organized ourselves to have a public hearing to discuss about implementation of special autonomy. At the time, I was working as an advisor for the Papuan People Assembly. Papuan People Assembly is created under the special autonomy law. It is a local governmental body, but because of military and police think that we are organize or do some separatist or terrorist activities, and they come and arrested us. I was in the police custody for 2 days, and released because of they don't find the evidence. But the problem is after release and they follow. So I feel like I not feel free. Imagine every night when you go to sleep, you don't have, feel free to sleep. Still in the in the fair. So this is the example that the link between militarizations and the economic development project. And if we look back to the colonizations, it is exactly example of the colonizations. So Indonesian government argued that West Papua is not a colony, but what they trade with the West Papuans, it is a colonial approach to West Papua. I ended for now, and I'm looking for discussions. Thank you so much. Amakane, kia ora.
Thank you so much, Wednesday, for your talk, and to be a voice for West Papuans. It's not something that I think even here in Australia we're so close geographically that is really talked about, and I think the military control over your communities is a lot, like, this is the consequence of what such coercive power does in silencing our voices. So it's an absolute privilege to hear from you today. I think what I notice in hearing from the three of you is that even though we might have these rights as Indigenous peoples, if they're not able to be enforced, if there's not accountability mechanisms, if there's coercive control by these colonial systems, what good is the rights, and how do we move forward in light of that? I guess with that being said, we've got a number of people joining us overseas today, and I'd like to first start with Carwyn, whether you have any thoughts on how people can provide allyship and support for Indigenous struggles in the Oceanic region from afar, and that.
Yeah, well, I mean, one of the things that's been really interesting with the current issues we've been dealing with is the allyship and solidarity from settler population in Aotearoa, but also from people overseas as well in different countries. And partly that was what was so effective about I had the image of Hana doing the haka in Parliament, and the way that went around the world and brought attention to these issues was really important. So I think one of the things that people can do in solidarity is keep raising these issues and bringing them to the attention of not only our government in Aotearoa, but their own governments wherever they are, or of international organisations, because one of the things that we know is that often our politicians don't like to be embarrassed on the international stage, and certainly in New Zealand, generations of New Zealand governments have prided themselves on being kind of world leading in race relations, and that's never really been true. But certainly to be able to have attention brought to bear on these issues through international processes, through international engagement, I think is really helpful.
Thank you so much. Yeah, absolutely. Bringing light to this, and whether it's in your capacity as an academic or a lawyer, or also just having these conversations with people and bringing these issues to light is really important. Virginia, do you have any thoughts on this?
Yeah, I think that it's really important in one respect is to have our young people and certainly aspiring advocates in various areas, no matter what they be, have opportunities when they go to university to explore and understand the international system and how it works. In the United Nations, particularly in various areas, there's an amazing opportunity for Pacific Islander and Indigenous peoples through the ANU Scholars Program. Last year, we also, I was one of the members that chose those people to go over, which was One First Nations and other representatives of the Pacific Islands to COP in Baku. And it's invaluable. And I've seen when students have come back that they're inspired and they see their work as a thesis, not just as a technical work, but a living and breathing opportunity to know how the system works and how to improve those skills as an advocate, and to really share and return home inspiring other young people to really take a journey in these particular areas and use their cultural knowledge and their ability to be certain of their identity, or to improve and embolden them to be amazing representatives in a whole range of areas. So, you know, I've seen that when they've returned from COP and being inspired. And I think that's what we need to do, because there has to be succession planning. It's really critical in all of our communities, because many times we just leave self-determination to several groups, but we don't include perhaps the youth in the way that we should. And I think those examples will give people heart to also work on those issues in their communities.
Absolutely. Thanks, Virginia. Yeah, this is a long path and a long struggle, and so building up capacity in our young people is incredibly important. And for those watching, hear what Virginia is saying and think about the opportunities that you might be able to help provide young people at your institutions. Once you get a taste for it, there's no backing out. This is a lifelong commitment, and I think whether you're Indigenous or not, you know, this is something that speaks to our human nature, and it's a very important message. I'd just like to, before we wrap up today, also like to hear from you, Wense, about how we can help best support West Papuan voices and Indigenous struggles from afar. If you have any thoughts there.
I think very interesting when we deeply reflecting on West Papua case, because, you know, in the political side, West Papua part of Indonesian administrations, but in the cultural, West Papua part of the Pacific or Oceania. So I learning from West Papua case, I think for us as indigenous peoples in the Oceania, we have to decolonizing colonial geography. I mean, during the colonial era, they try to classify us like Melanesians, Polynesians, and Micronesians. But sometimes they make us confused. So we have to come with our indigenous knowledge that, like, I am Papuans. I have a similarity with my brother and sister in Papua New Guinea, because we are Papuans. But when we go to the Fiji, oh, they are Fijians. And then to people in New Zealand, in Aotearoa, Maori peoples, it is the same. So we have to decolonizing first. And we use our indigenous knowledge to waving our solidarity. Because if we have a solidarity, it means it is a sign of hope that we will make a more contribution for the future, not only for our future, but everyone's who living in the earth. So these the ones. And then second, I think more sharing experience, like now we're sharing from Maori and from Australia and from West Papua. It is a space that we can learning and inspiring each other. Like I am now in Aotearoa, I'm learning from Maori how they're dealing with the agreement with the British. So I'm learning from them, and I talk back to my family back home in West Papua that this is some things we have to learning from Maori people. That's important. We have to also look at how do we do in our land in West Papua. This is the and then the last thing from me, it's how to strengthening our networking and solidarity, and using as a space to bring one voice from the Oceania to the international advocacy. Like I just back from Riyadh, that now we have Indigenous caucus. How to using the Indigenous caucus, because we come from the 7 regions, Latin America, Eastern Europe, Pacific, Asia, and other regions together and bring one voice. That we need our voice to be heard in the UN meeting, and quite good that member state they adopted. This is the example that when we become united, we become strong, but not only strong, we inspiring to find our better future. Thank you.
Thank you so much, Wense. Absolutely, we can stand strong with each other, but we also need the international community to stand strong with us too. So for those watching, think about your duty in this struggle too, and what that you can do in your own settings to further this. I think, unfortunately, that's all we have time for today. It's been so wonderful to hear from you all. It really, this is just the beginning of discussions, and I look forward to other similar panel discussions that Jonathan mentioned in this series. Before I conclude, I'd just like to say thank you so much, Jonathan, for organising this, and thank you to Dr. Virginia Marshall, to Dr. Carwyn Jones, and to Fataban Wenceslus for joining us today. You all speak from your heart, from your experience as Indigenous peoples, and it's an absolute privilege to hear from you. I'd also like to thank Charlene from the ANU College of Law for helping arrange all the technical support behind these webinar series, as well to Azul and Law Asia for co-hosting this. Yes, as a call to action, we've all heard it today, so go spread the word, go out into the world with this new knowledge. Thank you.
Thank you.
Thank you.
Thank you so much.